products. It won't happen in this bill, but what we need is a bill like 20 other states have passed that draws a line in the sand. Here's kratom. Kratom is just the products made with the leaves of the kratom tree, which is in the coffee family. And if it's adulterated with kava, with 7-hydroxy or boosted alkaloids or all these crazy things, it shouldn't be allowed, in my opinion. And on this, I agree with FDA and DEA and my old institute, NIDA, which in July announced that they're recommending that 7-hydroxy be put in Schedule 1 of the Controlled Substances Act. I've been doing 8-factor analyses for that act since 1980s, and I submitted a thorough analysis essentially to help them with it. I checked this morning, and my current kratom library is up to about 1,000. If you need any scientific literature, I can provide it. Of my own approximately 500 articles in a book on kratom that just came out on the international state of kratom research, that includes about 20 of my own articles and studies, including measuring 7-hydroxy and mitragynine and looking at the safety and the addiction potential. So anything I can do to help the committee with its deliberations now and going forward, hopefully, to get more regulation that makes sure that the estimated 500,000 adult Minnesotans who are using kratom, mainly for health and well-being, that's based on NIDA-funded surveys, can get, when they buy the kratom, like if I get this water bottle, I know the level of toxicants. It's not distilled water. Standards are set. You can do the same thing for kratom. We do it for dog food. We do it for coffee. We should do it for kratom. That'll take more time, but I can provide any resources that you need in that process. Thank you very much.
Thank you, Dr. Henningfield. I've got one comment and one really important question for you. The comment is that you are another exemplar of public higher education that has worked well in Minnesota. So we're glad that you were able to take advantage of the resources and opportunities here at the University of Minnesota. Secondly, you got to clear this up for us because I've heard it a variety of ways. How do you pronounce the word that is spelled K-R-A-T-O-M?
Well, there's kratom. I pronounce it kratom. And when I went to Southeast Asia, they said kratom or kratom. And 7-hydroxy, it's 7-hydroxy mitragynine. If you drink coffee, that's got 30 or 40 of what we call alkaloids. They have nitrogen ring on them. And kratom has more than 40 alkaloids. The main one that gives people benefits is mitragynine, and that's among the safest ones. Nature got it right in that. Being natural doesn't make something safe, but in this case, nature got it pretty close to right. 7-hydroxy basically is not in kratom. It can appear at very low levels by natural hydroxylation of the mitragynine, but products that are boosted in 7-hydroxy, that's synthetic. And they misrepresent, it's a masquerade. Products say kratom-derived whatever. And a lot of the increase in adverse events to the CDC and FDA are almost certainly 7-hydroxy related and other contaminants. And as a state, you can make sure that standards are set, and anybody that sells kratom, it cannot be chemically manipulated.
Well, thank you, Doctor, and we're losing our 2 physicians after this legislative session in the State Senate. So perhaps Dr. Senator Mann can figure out someone else who can pick up that ball for next year. Any questions for Dr. Henningfield on the Senate File 3704 that's in front of us? Senator Limmer.
Excuse me, I'm going to turn my hearing aids down. I'm getting echo, so if I apologize if I don't. If you speak a little bit more slowly, that might help, but I'm getting a lot of echo.
Senator Limmer speaks slowly, so go ahead.
Thank you, Mr. Chair. Doctor, I appreciate your work and I appreciate the description of Kratom, but could someone tell me why the justification to change the age from 18 to 21? As you may know, we recognize adulthood in the state of Minnesota. We allow 18-year-olds to vote federally in the state. One can be drafted at 18. I haven't heard the justification for moving the age from 18 to 21, and could someone tell me that?
Sure, yes. And
Henning.
like everything I talk about, there's got to be some kind of evidence. The first thing is that the early studies of kratom showed that the vast majority of people that used it were over 21, mainly in the 25, 30 to 60-year range. And so setting that minimum age at 21 isn't really going to hurt people that are mainly needing it. But the second thing goes back to the same reason that me and others supported going to 21 for tobacco products. It is 3 more years of age for people to learn about things, hopefully mature more, make better decisions. And in every state that implemented that, and Minnesota was among the earlier ones, it did make a difference at the state level and ultimately at the national level on reducing youth smoking. And I think the same applies likely for kratom.
Mr. Chair.
Senator Limmer.
Doctor, could you tell me, is there a danger to consuming kratom?
The risks of natural kratom are relatively low. And what I base that on is when I started working about a dozen years ago, there was little data in the United States, so we turned to Southeast Asia, and they're public health people. And I do international work. I've worked with WHO on their committees for 17 years. So I can get that kind of information. And what they told me was really surprising. They said, we haven't seen documented actual kratom deaths. I said, what do you mean? I said, we haven't documented, and people use it in place of coffee and tea. That's the main use over there, because at low doses, you get a stimulant-like effect. And it's in the coffee family. Now, in Sweden, in 2009, there were 11 deaths associated with kratom. It turned out to be an adulterated product. It took a few years to find that out. I did one of the first studies in animals trying to find if mitragynine, what the lethal dose was. We pushed the doses literally as high as we could based on the physiochemical parameters, tens and tens of times higher than people take or could tolerate without throwing up a lot. We couldn't kill the animals. We couldn't produce respiratory depression. So the elements that are in kratom, natural kratom, are either at extremely low levels or the mitragynine constituent has what we call a ceiling, a partial agonist effect that keeps it from producing overdose. 7-hydroxy is different, and we saw early on that 7-hydroxy was a problem, and again, me and others advised American Kratom Association, advised setting a limit on 7-hydroxy on kratom products, and we came up with 1 or 2%. States differ, but at that level, it's probably almost impossible to hurt yourself badly. Nothing's impossible, but FDA's conclusion on kratom is that kratom-related deaths are rare and generally involve other substances. NIDA says the same. DEA doesn't even list deaths. So you can never say never. There are a couple of caffeine overdoses every year, but they're pretty rare.
Thank you, Doctor.
Mr. Chair.
Any other questions?
Can I add to
Senator
that?
Mann.
We're doing this also because the poison controls have gotten over 3,000 calls in about a 5-year period, and every year those calls go up as more and more people are being introduced to the product. It can cause liver damage, delusions, depression, seizures, and addiction.
Senator Holmstrom.
Thank you, Mr. Chair. In preparation for this bill, I called some people I know in my district that do drug rehab or run AAs, and their response was that this substance has very, very severe withdrawal effects, and that their recommendation is that people shouldn't even have it available at all. Can you speak to the withdrawal or your opinion of your knowledge
Yes,
of that?
2 years ago, I convened, I'm sorry.
Go right ahead.
Okay.
I just have to identify you for the public record that's being
Okay, I'm
kept
Jack
here.
Henningfield again. 2 years ago, I convened a virtual think tank of a representative from every laboratory in the world that was doing withdrawal-related research in animals or humans, and invited the National Institute on Drug Abuse to attend. They had 3 people attending. We published the results. The conclusions were that 7-hydroxy, it looks like it can produce more of a morphine-like withdrawal. Mitragynine or alone or kratom appear to produce very mild withdrawal that is also clinically different in certain ways. It doesn't have as much of the anxiety and some of the other effects of opioid withdrawal. A myth was that if you can use mitragynine or kratom to relieve withdrawal, it must be an opioid, but we've been using clonidine and lofexidine to treat opioid withdrawal for decades, and actually mitragynine has some of the same effects as lofexidine. It's a fascinating natural chemical. So can you get withdrawal? Yes. The vast majority of severe withdrawal appears to be polypharmacy, and it looks like the vast majority of reports to CDC are polypharmacy, though the reports, the data set are not great. At Johns Hopkins, my colleagues with the National Institute on Drug Abuse have done a lot of follow real-world studies where people are using monitors and reporting data the same way we do for FDA studies of drug efficacy. And so they track it over time, and they come up with the same findings. There are some people, like with caffeine, that have stronger withdrawal than others. But overall, if it's really strong withdrawal, it most likely is polypharmacy. Again, another
Senator
reason for
Holmstrom.
regulation.
Briefly, Senator Holmstrom.
Thank you, Mr. Chair. So, Senator Mann, you had mentioned poison control had 3,000 calls. Was that just from Minnesota? And do you know the ages of what those calls were in reference to?
Senator Mann.
Thank you, Mr. Chair. Senator, that was national. I don't know the ages.
Any other questions for Dr. Henningfield? We do have one more testifier. Doctor, thank you for joining us here today.
You bet. And if you need anything at any time, contact me directly. I'm happy to do whatever I can on my own time to help.
Thank you so much. We
Thank you.
appreciate that. Ryan Haugen, you're on virtual, remote. Why don't you go ahead and introduce
Yes.
yourself and tell us what you'd like us to know.
Yes, my name is Ryan Haugen. Chair Latz and members of the committee, thank you for allowing me to testify.
Can you get closer to your microphone, Mr. Haugen?
Yes, is this any better?
Not much. Maybe speak up.
How about now?
That's better, yes. Thank you.
If it works for you, it works for me. Okay. My name is Ryan Haugen. I'm a professional narrator and voice actor, and I'm speaking today in support of SF 3704. Whole leaf kratom has made an enormous difference in my life. I live with CPTSD and panic attacks, and before kratom, anxiety shaped nearly every part of my day. It made it harder to be in crowds, harder to speak publicly, and harder to function in any profession that required confidence, communication, or creative focus. Using small, responsible amounts of whole leaf kratom helped me regain stability. It helped quiet the panic that used to run my life. It helped me feel present in the world again. Today, I narrate audiobooks and voice characters in video games. I recently proposed to my partner of 9 years. I do not say lightly that whole leaf kratom helped me build the life I have now. I also know I am not alone. Kratom is used by millions of Americans, often as part of a daily wellness routine or as a tool for self-management of pain, anxiety, or other challenges. People report using it because they're trying to function, work, parent, and live normal lives. That is why I support a reasonable regulatory approach. What concerns me most is not whole leaf kratom, but the unregulated market for highly concentrated and synthetic-like products, including 7-hydroxymetrogenine products. Those products are not the same thing as traditional whole leaf kratom, and policy should not collapse that distinction. If lawmakers want to address real risks, that is where the focus should be. A narrower, more workable approach like SF 3704 makes sense. It allows Minnesota to respond thoughtfully rather than overcorrect. It protects the public without criminalizing responsible adults who use whole leaf kratom carefully and without treating the plant itself as interchangeable with more potent compounds. I appreciate that Minnesota has shown a willingness to take measured, reasonable approaches to difficult issues. I believe this is one of those moments. Clear, targeted regulation is better than broad prohibition, and it is better than allowing an unregulated market for more dangerous products to keep expanding. And as for the matter of withdrawal, I skip kratom all the time, and at the very worst, it has felt like skipping a cup of coffee in the morning. I just wanted to get that on the record. Thank you for your time and consideration.
Thank you, Mr. Haugen. Any questions from members of the committee for Mr. Haugen? Senator Westrom.
Mr. Chair, I guess to the testifier, but Senator Mann as well. Senator Mann, can you refresh me? The current policy is at 18. You can obtain over-the-counter kratom, whatever you call it. Is that correct? And then to the testifier, if he's finding a helpful use out of it and we're raising the age to make it more restrictive, those two things don't seem to go together, Mr. Haugen. So if you can answer that subsequent to Senator Mann's answer, I'd appreciate it.
Senator Mann.
Mr. Chair, Senator, that is correct. It's 18, and you can get it at convenience stores, gas stations. You can buy it online.
Mr. Haugen.
Well, this would be just a matter of my opinion, of course, but I think that it makes sense to have it regulated along the lines of things such as alcohol. I think that keeping it just towards that market feels like it makes more sense to me. And I'm of the mindset that the same could probably be said for cigarettes too. It is like a cup of coffee to me, but there are issues currently that I think are not being properly addressed, and this has to do with the labeling of the product and how it is marketed. You could certainly take that approach. I think that there's a good case to be made that perhaps it shouldn't even be in gas stations at all, specifically speaking of the synthetic compounds. But I think considering this is the track we seem to be on right now, this is something that needs to be done until things like product labeling and proper standards can be in place.
So thank you, Mr. Haugen. Senator Westrom, follow-up?
Mr. Chair, thank you, Mr. Haugen and Senator Mann. How do most people take this, and you as a doctor, do you prescribe it sometimes or recommend it to people for anxiousness and situations like the testifier gave us?
Senator Mann.
Do they chew a leaf? Do they drink a hot drink with it? Just give me some examples to get a little more familiar with this idea.
Mr. Chair, Senator, all of the above. You can put it in, you can make a tea with it, you can make it into a powder, you can crush the leaves. I do not prescribe it for multiple reasons, including there's a lack of studies to say that there's any actual medical benefit to this leaf. The issue, so this is a part of a much bigger conversation, and that is the regulation piece. Because manufacturers of this product are adding in synthetic ingredients, we're seeing more side effects than people are seeing, say, across the ocean, where they do this more regularly. And so we do have to have a conversation about proper labeling of what's going into the product that people are buying. And until then, all sides of the stakeholders have agreed to at least go from 18 to 21 to keep it more consistent with, again, with tobacco and alcohol, and to protect our younger people.
Okay.
Senator Westrom. You done? Senator Holmstrom, discussion.
Thank you, Mr. Chair. Senator Mann, when I do some research on this drug, we hear that taking it with alcohol could induce respiratory depression. This could be fatal. And we kept talking about the 7-hydroxymetrogene being the real danger there. If people are potentially at a position where they could be in a fatal situation because they don't understand what this product is because the labeling isn't what it is, I'm not sure it matters if we raise it from 18 to 21. I think we need a lot more severe restrictions on this to protect the public. I'm not sure your bill goes far enough. Are we out of time? Do we not have time to do this more robustly?
Mr. Chair,
Senator
Senator. Kind of. This is a much bigger conversation that we had time for this year. And you're right, we have, poison control has gotten calls and there have been deaths due to polypharmacy, so mixing this with other things. And again, labeling and what people are putting into their products is the big issue here. And so we are trying to walk that fine line between the people who take the natural kratom leaf who have benefit of multitudes of different kinds, between the manufacturers who are putting in synthetic products into their kratom and causing side effects, increasing side effects, and even death. And so, yes, it is a much bigger conversation, and we do need more regulation. You're absolutely correct.
Senator Holmstrom.
Thank you, Mr. Chair. So when I had those conversations with people that have used this before, they didn't specify that there was a difference between the leaf and and what they buy at the store and poly, whatever. Their experience with it was that they just went into the gas station or into the tobacco shop and they paid for a product and they had no idea what was in it. And I'm not even sure if labels go far enough here. I have a real fear that even if we just raise the age at 21, we're missing so much of the conversation, and so many people are going to be in serious danger without really realizing it. I don't think we're going far enough at all. Thank you.
Any further discussion on Senate File 3704? The next step members will be the Senate floor. Senator Westrom.
Mr. Chair, just briefly, I guess I'm still pondering 18 to 21. Senator Limmer's question, but a little bit on Senator Holmstrom's vein, more on the labeling. Senator Mann, why don't we just focus on the labeling and not raise the age limit? Reading up on it briefly here, it looks like Southeast Asian countries use this quite a bit. Why not just label, and then people can be informed, and if they use it like the testifier presented to us, maybe there's some helpful benefits as long as people are using it, just like aspirin, just like other over-the-counter medications. Too much of anything is a lot of times a problem. Why are you not doing more on the labeling now? And that seems to be the most helpful we could be to the public. But
Senator Mann.
Thank you, Mr. Chair. Senator, we are working on that. We had another bill today, which just wasn't ready. There's conversations about what the labeling needs to include, and of course, we don't quite know the dose of each alkaline that causes each specific side effect. So what would be allowed into any product is also still under discussion.
See no further discussion, Senator Westland moves that Senate File 3704 be recommended to pass and referred to the Senate floor. All those in favor say aye. Aye. Opposed? No. Motion prevails. Thank you, Senator Mann. You set us up nicely for next term. All right, Senator Rest, come on forward. Okay, members, Senate File 3900 is before us. There's also an amendment being handed out that was adopted in state and local government, but in the engrossing process did not get attached to the underlying bill. So all we're going to do is clean up that clerical procedure. Senator Westland will move adoption of the A6 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Rest to Senate File 3900.
Thank you, Mr. Chair, and I appreciate the courtesy of correcting the error that had been made, getting this bill from state and local to Judiciary. It's before Judiciary because of Section 1, but because there's a penalty increase for knowingly misrepresenting or changing documents by a state employee, increasing the penalty for to a felony. But I think, with your indulgence, just a couple of minutes in explaining the genesis of this bill that's before us.
Please just try to keep it focused so we can.
Yes, I'm just.
Direct our
yes.
attention. Thank you.
We, this bill really is the work of the Legislative Audit Commission itself. And one of the things that I believe going forward is going to try to establish a tradition of the Legislative Audit Commission bringing forth legislation that reflects findings from various reports and that are done by the auditor's office to put them into general law. So that's what this, that's the genesis of it. And in state and local, Mr. Chairman, there was a question from Senator May Quaid about a reference to how you go about making decisions about high risk. And we didn't have time dealing with high risk situations with regard to grantees. And we didn't have time to respond to, in that hearing, to her question about it. So been working with the legislative auditor since then on clarifying that that particular question that she raised, and would appreciate, if possible, the committee considering the A7 amendment, which you have.
Okay, the A7 amendment will be handed out.
Thank you, Mr. Chairman.
Senator Rest, could you
Yes.
help us understand why this amendment is here? It's to a provision in the bill that's not really before this committee's jurisdiction.
I guess I didn't explain as well as I should have. There was a question raised by Senator May Quaid in the state and local government, not enough of an objection to not forward the bill, but asking for clarifying information about one section. And the auditor and I believe that Senator May Quaid would be satisfied by now with this amendment. If you care not to do it, I'll wait to do it on the floor or wherever it's next. But it's more of a clarifying amendment to language rather than a substantive change.
Senator Rest, do you know what the chair of state and local government's position is on this committee acting on a portion of the bill that's within their jurisdiction?
I don't. We did not go back and check with them, Mr. Chairman. If you don't want to take it up, I'll do it later.
All right, why don't we hear from your testifier, Auditor Randall. Welcome to the committee.
Thank you, Mr. Chair, members. For the record, Judy Randall, Legislative Auditor. Thanks for taking the time to hear this bill. as Senator Rest said, when we heard it in state and local government, Senator May-Quade questioned the use of the word high-risk grantees and grant programs, which is currently on line 4.22 of the bill. And she asked if there was a definition in law or in this bill for high risk, and there was not. And so we worked with Senate Counsel to put a finer point on the intent of that line. The intent of that line was to give the Department of Administration some discretion to use their resources as efficiently as possible and focus their oversight on the word I was using was high-risk grantees, but so we tried to define that a little bit more in this section. So it was responsive to a question that Senator May-Quade asked in that committee, and at that time, Senator Rest said we would work on it and try to present clarifying language here.
So I understand that, but I don't want other committees to deal with judiciary issues, and I don't like to deal with other committees' issues. So unless we get Chair Zhang's approval to go ahead and add it.
It's fine,
We'll
Mr.
let you deal with
Chairman.
it on the
I don't
floor,
want to take
Senator
any
Rest.
more of your time than I need to.
No, I appreciate that. You, I know,
I
understand the
appreciate, and
jurisdictional
I no
issues.
objection. Just thought we'd try.
Fair enough. Okay. We do have Section 1 before us, which addresses the crime that's created here. Any discussion, or Ms. Randall, did you want to address that particular provision at all before we open up the floor here?
Well, maybe I could talk to
Senator
it
Rust.
first. Thank you very much. The original finding from the auditor's report made that activity, that illegal activity, quite frankly, subject to just being dismissed from their job. And in further reflection, we, working with administration and, and MMB and revenue, that kind of misbehavior was more appropriately considered to be considered a felony. So the language was then included and amended to reflect that, the results of those conversations.
Auditor Randall, do you have anything to add?
Thank you, Mr. Chair, members. What I will note that 60943 is existing law about misconduct of public officer or employee. And as you may recall, we released an audit in early January of this year, during which we identified that some state agency employees had falsified documents and then provided them to us in the course of the audit, some misrepresented information. And so when that happened and we reported on that, there were questions about, well, you know, isn't that a crime, and how can that be? And so what we discovered really is that 609.43 was the closest that came, but it was kind of oblique, frankly. And so Section 1 of this bill really just clarifies that providing information to us, then, you know, if it's falsified information, then it would be subject to 60943. So it's really, in our view, just clarifying the existing law, but making it very clear to folks that cooperation with OLA and providing accurate and truthful information to OLA is important.
Any questions from members of the committee for Auditor Randall or Senator Rust? Senator Carun.
Thank you, Mr. Chair. Is Section 14 in our jurisdiction now that it's been adopted?
Senator Carun, you're referring to a new section that was adopted on the A6 amendment, which we did merely as a clerical courtesy. It is not within the jurisdiction of the Judiciary Committee.
Thank you, Mr. Chair. I understand that we adopted it as a professional courtesy, so to speak, but does it not touch on liability for retailers? My understanding is there was very little discussion about that amendment in an otherwise really good bill, but increasing liability for the retailers in lottery sales, it seems like it could be within the Judiciary Committee. That's why I asked.
Mr. Chairman,
Senator, I'm going to note the A6 amendment was added by state and local government as a part of their consideration. There was a clerical error in the engrossing, which is why it didn't show up in the first engrossment that we have distributed. So that was their jurisdiction. I don't want to get into that. All right, Senator Rust.
thank you, Mr. Chairman. Yeah, it was very awkward to have that mistake made, because since that time, the amendment that was the A6 has generated a lot of discussion that if it was just being offered, might not have resulted in it being passed. But it was passed in state and local with very little discussion. And so it seems to me would be a disservice to Senator Drazkowski, it's his amendment, to not adopt it as a courtesy, because it really does speak to custom and usage in terms of when a mistake is made. And to turn a mistake into a point of controversy seems to me to be not recommended.
Yeah,
Mr. Chair.
Senator Rust, we've only dealt with it as a clerical matter. The other committee acted on it. We're not going to go into a discussion of state and local governments' consideration, long or short, deep or shallow, of those provisions in the other committee. Senator Kroon.
Mr. Chair, thank you. I'm not suggesting, I mean, the amendment's already been adopted, and I'm not suggesting that we rescind adoption of that amendment or anything like that. I just thought it would be appropriate to open it up for discussion, given the fact that the people that are going to be potentially or negatively impacted by it had no opportunity to testify in the State Gov Committee.
Senator
And so-
Kroon, I'm sorry, that was their committee's decision,
Yep.
not ours. We're not going to open up discussion and testimony on a provision that was adopted in a different committee over which we have little or no jurisdiction.
Thank you, Mr. Chair, and that was
Thank
the
you, Senator.
question, that was why I asked the question about our jurisdiction.
And I've
we'll
answered the
just have
question
to-
several times now, Senator Kroon.
Very good, we'll have this discussion on the Senate floor then.
That's
Thank you.
just fine, Senator Kroon. That's where it belongs. Any other discussion on Senate File 3900 as amended? All right, I'm not seeing any. Senator Seeberger moves that Senate File 3900 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? No. Motion prevails.
Thank you, Mr. Chairman.
Thank you. And members, we have a lot of work to do. Really want to focus our attention on this committee's work. If some other committee didn't do the work that you think ought to have been done, take it up with that committee or however that was
Mr.
handled.
Chair?
We're not going to go
Mr.
down that
Chair?
road. Senator Kroon.
I appreciate that we have a heavy agenda. My concern was legitimate, and I do believe we had partial jurisdiction over that section, and we should be doing as much work as possible. I understand we have a heavy agenda and you want to get moving, but my points were legitimate.
The record will show no. Senator Kroon says his points were legitimate. Senator Howe?
Mr. Chair.
Senate File 3964. Senator Westerman, is it the Senate File 3964?
It is, because it's on the agenda. Mr. Chair.
Is it on
we
the
had
substance
a
of Senate
meeting
File
canceled on Monday
3964?
where we would have had 2 more hours. We could have covered stuff.
That's correct,
So
Senator
This is a little
Westrom,
bit of
because-
a management issue that we shouldn't be chided for by the
Senator
chair.
Westrom, the meeting was canceled on Monday because we had to plan to dedicate several hours to a bill that generated so much procedural debate on the Senate floor, and it was shelved there, so we had nothing left on our agenda. So there are consequences to what happens in other parts of the legislature. And if the one item on our agenda that we think is going to take 2 hours gets torpedoed on the Senate floor for whatever reason, and deprives this committee of an agenda for that day, then we're going to cancel that. So we are now on the substance of Senate File 3964. This is Senator Howe's bill, and I'm going to ask Council, this is the first reading of this bill, first committee. So I'm going to first determine where this is going from here. Looks like it goes to the Senate floor. Labor has asked for it or not?
Labor passed on that.
So the Committee on Labor apparently has passed on their jurisdiction. So the Senate floor is the next step. So the entire bill is within this committee's jurisdiction. Senator Howe, please describe your bill.
Thank you, Mr. Chair. And Senate File 3964 is there to address what many folks, many of us and many homeowners deal with all the time, and that's smoke detectors that don't work. And what this would do would require that when you replace a smoke detector, you would replace it with a smoke detector with a 10-year battery. And then that way, in 10 years, when that smoke detector finally does beep at 2 o'clock in the morning, you take it down and replace it. They all have a date on them. They're all good for 10 years, and that way, that 10-year sealed battery would take it for the life of the detector. This bill does not increase the number of smoke detectors, doesn't change the location. All it does is require you, and if you're going to replace one, you replace it with a 10-year battery. And I know you've all seen the news of a fire lately that killed a mother and their 3 children. I'm telling you what, that's what we face when we don't know if the smoke detectors worked in that home, but that is the best way to get your family notified and get out of a home is having a working smoke detector. It used to be before 1970, you had 15 minutes to get out of a home. With today's environment and the products that we are now putting into our homes, you've got less than 3 minutes to get out of the house. And so if you're trying to wrestle up a couple of kids to get them woke up and out of the house, you need all the time you can get. And if you've got a smoke detector in the wrong place that's not working, you're putting your family at risk. But that is the crux of the bill. It's a common sense bill that would just say if you're going to replace the smoke detector, you replace it with a smoke detector with a 10-year battery. Thank you, Mr. Chair.
We have one testifier signed up, Joel Selwood. Go ahead and testify.
Thank you, Chair Latz and members of the committee. My name is Joe Selwood, and I'm testifying on behalf of KIDA in support of Senate File 3964. Minnesota's State Fire Code requires that battery-powered smoke alarms be replaced every 10 years. This bill ensures that when replacement happens, the new alarm is equipped with a 10-year sealed battery, one that stays active and reliable for its full service life. It is a practical, proven step that helps protect residents, especially children, seniors, and the most vulnerable. According to the National Fire Protection Association, a home fire occurs every 90 seconds in the United States. Nearly 3 out of 5 home fire deaths occurred in homes without a working smoke alarm. And when alarms were present but failed to operate, missing or dead batteries were the most common cause. Battery failure, whether from removal, tampering, or neglect, is the leading reason a smoke alarm is silent when it matters most. The NFPA also states that a working smoke alarm nearly doubles the chance of a successful escape from a fire. Smoke alarms equipped with a sealed 10-year battery prevent tampering and eliminate the potential for human error that exists with battery installation. That's why legislatures in 12 states, through legislation, have enacted this policy, and the products are there to meet it. All major smoke alarm companies manufacture these products, and they are already carried by all major retailers. The state fire code requires smoke alarms to be replaced at 10 years from their manufacture date. Senate File 3964 completes that requirement by ensuring the replacement alarm can fulfill its 10-year purpose. We want to thank the Minnesota Safety Council for their support and Senator Howe for his leadership on this issue. We appreciate the committee's attention to this important public safety measure and urge your support for Senate File 3964. Thank you. Happy to answer any questions.
Thank you, Mr. Selwood. Any questions or discussion on Senate File 3964? Senator Limmer, then Senator Holmstrom, then Senator Seeberger.
Thank you,
Senator
Mr. Chair. Senator Howe and I have discussed this. I also have discussed this proposal with Mr. Selwood. We often get requests from building manufacturers to include certain products in home construction. And over the years, the legislature has had kind of a checkered past with trying to determine what is the best product to put into a home and what is not. You might recall in the year 2000, we had an energy code that was created by the legislature, not by the building codes and standards people at DPS. Those are the homes that got mold inside the walls, and the builders got sued because they followed state law. And then the building code that they followed was approved by government inspectors to inspect that because it was written into the law. And whenever I see a bill like this, I get a little nervous that the legislature, who doesn't always know all of the finer points of adding components into a residential home, is necessarily the best way to do it. I'll be passing out a letter from the Department of Public Safety, and if I could have a page pass this out, I'd appreciate the committee members looking at it.
It'll be handed out, Senator Limmer. Please go on.
And I also have an amendment that I'd like us to consider. But let me first talk about the bill and the direction we're going. Thank you, Senator Howe, for bringing this issue before the committee. It is important. Technology is changing, as you have stated. There is a 10-year battery that is reliable. I don't know if every competitor makes one that's in this field of manufacturing smoke and CO2 alarms, but nevertheless, it looks like at least one company does, and they in turn want to have the state adopt a law that requires what they make. In the letter that I put out, oh, and one other thing I might want to add, I think we are going in the right direction with the spirit of the bill that you have, Senator Howe. We should try and keep up with technology that brings us to a better product. Department of Public Safety, builder standards and codes, folks, they always try to catch us as legislators. Please don't do it until we look at it. In my profession, I've seen where building components actually don't act together well. These wraps that go around houses that stop wind intrusion, if they're added to a certain sheathing, they dissolve over a couple years, and you don't have anything. That 2000 building code that I mentioned also created more problems because the legislature created it. The amendment that I have, it's the A1 amendment, Mr. Chair. And I'd like to introduce it at that time and kind of go full circle on my discussion.
We've got them all.
I have talked with Senator Howe about this, and I'm just bringing it before the committee.
Members, the A1 amendment has been distributed. Senator Howe, what's your position on A1 amendment?
I understand it. I actually, when Senator Hoffman brought his CO alarm detection amendment, I kind of thought that that's the direction it should have gone. So I'm not totally in favor of it, but I wouldn't oppose it. I guess sending it there and making sure that they take a decision on the amendment to the state fire code, I guess I would accept that.
Mr. Chair.
Senator Limmer.
Mr. Chair, just so everyone knows, including the public, the A1 amendment, instead of making this an edict from the legislature, we're directing the what am I trying to say? We're asking that the Department of Public Safety, through the state fire marshal, consider amending their state fire code to require sealed batteries for smoke alarms in dwelling units. And by January 15th, the fire marshal shall come to a decision on whether to amend it, the fire code, and begin the process to amend the code if they so agree. I did have an oral amendment that I wanted to add, and I'd like counsel to describe that.
Mr. Backus.
Mr. Chair, members, on line 1.9, after code, insert, so that the change is implemented in the next revision of the code.
So Senator Limmer incorporates that language into his A1 amendment. Any discussion among members of the committee on the A1 amendment? I'm not seeing any. All those in favor of adopting the A1 amendment as incorporated with council's language signify by saying aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Limmer, do you have any further discussion?
I do not.
Senator Holmstrom.
Senator Limmer carried all the weight there. I'm good.
Senator Seeberger.
Thank you, Mr. Chair. Senator Limmer's amendment took care of my concerns.
Any further discussion on Senate File 3964 as amended? Senator Westrom.
Mr. Chair, Senator Howe, we're to the, do you know what the price difference is going to be on detectors, and might that have a chilling effect on some people when it goes? I'm guessing it's going to go up, and would there be some unintended consequences here where somebody maybe can't buy a smoke alarm for $5, $10, or $20 anymore, and it's going to be $30, $40, or $50? What's your sense of pricing on these? Because generally, it seems like they're quite a bit more expensive.
Thank you, Mr. Chair. And I replaced them in both my cabin and my home, and I think it was about $35 for a pair of them, but I think my testifier, Mr. Selwood's got better information than that.
Mr. Selwood.
Mr. Chair, Senator Westrom, the average difference across 10-year sealed batteries versus those with replaceable batteries is about $10 up front. However, with the guidelines from battery manufacturers that you should be replacing your batteries every single year over the course of 10 years in a replaceable unit, that's either 9-volt or AA. I think that over the course of 10 years probably brings it right in line.
Any further discussion?
Mr. Chair.
Senator Westrom.
Mr. Chair and Senator Howe, as this goes forward, into the fire marshal, I just think that should be looked at a little closer, because I do think people will make those decisions, and I'd sure not want to have somebody make a decision to skip it because it's higher price. $10 doesn't seem like a lot, but to price-conscious shoppers and people living on a tight budget, it could mean the difference between even having one in your house and thinking you'll get it later because of the price. And that's a chilling effect. I guess I would just say let's be mindful of as this goes forward, because something is better than nothing, and that could be a choice somebody would make just based on price too, because we are now mandating a higher priced across the board in the market if somebody's going to replace it, if this was to pass. But just food for thought.
Any further discussion? Senator Howe.
Thank you, Mr. Chair. And Senator Westrom, I will tell you that as a as a rental housing inspector, the number one violation I write is either an out-of-date smoke detector or a non-working smoke detector that's sitting on the floor because the battery's taken out. And so I think this is a definite step in the right direction, and I think it'll save lives. And I think that's, I don't see where that $10 difference is going to really make a difference, whether, it'll make a life-saving difference if you, I think, update that smoke detector to the proper one. But I take your concern to heart.
Any further discussion? Not seeing any. Senator Limmer moves that Senate File 3964 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator
Mr.
Howe.
Chair.
We have Senator Port in the House. Senator Port, come on forward. Senate File 4171 is being distributed, members. Members, this is the first committee of jurisdiction. There are two amendments in your packets, the A1 and A2, that together would be considered an author's amendment. So Senator Clark is present. We'll have him move the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. Amendment's adopted. Senator Clark moves the adoption of A2 as the second part of the author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Port, tell us about your bill.
Thank you, Mr. Chair. The bill in front of you is sort of the poster child for how policy can be made here at the Minnesota Legislature. It brings together the interests and representatives of landlords and tenants to solve two specific problems. Sections 1 and 3 address an issue regarding the utility charges in multifamily buildings. 2 years ago, this legislature, in another bipartisan bill that was worked out among the interested stakeholders, revamped how landlords pass through utility charges to tenants. Last year, the landlords discovered a gap and brought the issue to legal aid. The problem this bill solves is how the final bill for utility charges is calculated. The law requires that utility charges to tenants must be based on actual bills the landlord gets from the utility, but often tenants move out on the 5th or 10th of a month before the landlord gets the actual bill. Sections 1 and 3 provide a fair formula for calculating prorated utility charges for that final month. Section 2 solves a problem that legal aid brought to the Multi-Housing Association. The days when you sent the landlord a check or dropped the rent off in the office are becoming relics of the past. Nowadays, tenants pay rent or request repairs or otherwise communicate with landlords through digital platforms, often called portals. Like all technology, they don't always work. This has become an issue. Section 2 of the bill provides that when the portals don't work, the landlord must provide an alternative means for the tenant to pay rent, request repairs, and communicate with the landlord. And it prohibits eviction when the rent is not paid because the system is down. I have Cecil Smith from Minnesota Multi-Housing Association and Ron Elwood from Legal Aid with me to answer questions for the committee if you have them.
Sorry, Senator Port, both testifiers are to answer questions. Do we want to hear? Let's find out if we have any questions.
Let's see if we have
Maybe don't
questions.
need
Yeah.
testimony. Any questions from members of the committee? Senator Limmer, to preserve the right to ask questions.
Thank you, Mr. Chair. Mr. Smith, could you tell me if your organization is in support of the bill?
Mr. Smith, go ahead and identify yourself as well, please.
Mr. Chair, Senator Limmer, Cecil Smith with the Minnesota Multi-Housing Association. Yes, we are strongly in support of the bill before you.
Senator Limmer, nothing further.
No other questions.
Mr. Elwood, your position on the bill.
Mr. Chair, members, Ron Elwood with Legal Aid, and we are strongly in support of this bill.
Any further discussion from members of the committee? I'm not seeing any. Senator Limmer.
Mr. Chair, I just want to congratulate the parties at the testifying table that they finally agreed on something. So thank you. Makes our job a little easier.
Mr. Chair, if I may, this might be my only opportunity. I think this bill is peace in the valley. I don't get to work on very many where I get to say that, so.
Senator Port. Smith, smile.
Thank you, Mr. Chair.
All right. Senator Port, my note says this goes on to the Housing Committee, or we have an option if you want to go to the floor.
To the floor.
Since you're chair of the Housing Committee, it's your decision. To the floor. All right.
Did we do the amendment?
Senator Limmer, do you want to move the bill?
Certainly, Mr. Chair.
Senator Limmer moves that Senate File 4171 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye.
Aye.
Opposed, motion prevails. Thank you very much. Thank you all. Mr. Smith and Mr. Elwood, don't go too far. Oh, wait, we're going to take one other bill up first. We're going to go to Senator Oumou Verbeten. You ready on yours? All right. Senate File 4154, Board of Public Defense. Senator Oumou Verbeten, when you're ready, go ahead and describe your bill to us, please.
Thank you, Mr. Chair. The bill before us today, Senate File 4151, is from the public defenders asking for a COLA wage increase. I am speaking in favor of this funding for Minnesota's public defenders through the Board of Public Defense. This legislation will address the growing gap between compensation and the cost of living for many of our public defenders in Minnesota. We'll also keep pace with their colleagues and make sure that those attorneys choosing to go into the public defender profession see compensation that incents new attorneys to join their ranks. Public defenders play a critical role in our justice system, ensuring that constitutional rights are protected and that every Minnesotan has access to fair representation. I know our committee is very well aware of that. Yet, despite this essential responsibility, many public defenders are struggling to remain in these positions due to compensation that is just not keeping pace with inflation and rising living costs. At the same time, workloads continue to increase. Public defenders routinely carry heavy caseloads, often managing far more clients than is sustainable for long-term retention or optimal outcomes. These pressures contribute to burnout, turnover, staffing shortages, and that's especially true in rural and underserved areas, and it makes it really difficult to recruit and retain those experienced attorneys there. The proposed cost of living adjustments are 1.25% in 2026, 1.75% in 2027. It's modest, but necessary steps towards stabilizing this workforce. And really the fear is that without action, we're going to risk losing skilled public defenders, increasing caseload strain on those who remain in the profession, and ultimately undermining the effectiveness of our justice system. Investing in public defenders is not just about the compensation, but again, it is really about maintaining a functioning justice system, ensuring timely case resolution, and upholding the constitutional rights of all Minnesotans. So I ask for the committee's support.
Senator Oumou Verbeten, you have two testifiers there with you. Kevin Kyer from the Board of Public Defense.
Thank you, Mr. Chairman. Kevin Kyer, I'm the Chief Administrator for the Board of Public Defense. This really is a very simple bill. It is an appropriation for the progression increases, and the cost of living adjustments that are on par with the executive branch. The question about why it is here. 90% of the board's budget is personnel. 96% of the board's budget is contractually obligated. And the majority of the rest of the budget is caseload driven. Public defenders provide only services that are required by Constitution or statute, and we provide service in the vast majority of all criminal cases in the state. Public defenders do not control our caseloads. Unlike other agencies, we can't reprioritize or we can't decide we're not going to do anything. And the biggest issue, and you've heard me talk about this before, is public defenders cannot refuse cases. So we really are in kind of a trap here of, if there are to be salary increases or wage increases, it has to come at the expense of staffing. This past year, over 80% of our representative staff voted for contracts that included a hard freeze over the next 2-year period. And they did that because they knew what impact those staff reductions would have on their clients, on their fellow defenders, and on the court system in general. So that's why we're here today with this bill. And I'm happy to respond to any questions that you may have.
Thank you, Mr. Kyer. Andrea Anderson, go ahead and introduce yourself, please.
Good afternoon, Mr. Chair and members of the committee. My name is Andrea Anderson, and I am a paralegal with the State Board of Public Defense. I work in the 4th Judicial District, Hennepin County, which handles the highest volume of criminal cases in the state. I have been a union steward for support staff in my office for close to 7 years. In this role, I represent my office's legal office assistants, paralegals, investigators, and dispositional advisors in day-to-day matters and also at contract negotiations. Support staff provide invaluable skills that allow public defenders to dedicate their time exclusively to the zealous representation of our clients, following our agents' client-centered representation model. Last session, other unions, including AFSCME, MAPE, and MMA, saw their collective bargaining outlays make it into the governor's budget recommendation. State employees in those unions receive step increases and a cost of living adjustment. Other agencies under the judicial branch, including State Court Administration and the Guardian Ad Litem program, received modest wage increases in their collective bargaining agreements. Today, I am asking that you vote yes on Senate File 4154 to uphold what's fair and commensurate with those unions' settlements. Thank you so much for your time today, Chair Latz and members of the committee.
Thank you, Ms. Anderson. Laurel O'Rourke.
Good afternoon, Mr. Chair and members of the committee. I'm a line public defender in the 10th Judicial District. I'm based out of Stillwater. My client was huddled next to me on a bench in a holding cell. A raucous from the 12 other men forced us closer together so I could hear what he was saying, and he was trying to speak low so as to keep some semblance of privacy as he explained to me how he found himself in custody on this Wednesday morning. It was an old warrant. He didn't even think it existed anymore because the charges seemed so insignificant to him compared to all of his obligations pressed up against him as a parent and a husband. The day before, he had gone out to pick up a balloon bouquet for his 7-year-old's birthday party, pulled over for a out taillight, and then he just disappeared. His face was wet and swollen from crying. He was still wearing his street clothes. There was more going on in that moment than I could glean from the 5 minutes that we had together to prepare his arraignment. Me in my wool navy blue suit that I hoped hid my utter ineptitude, and him in his Viking jersey and his rattling handcuffs. He whispered to me, "Please promise you'll do your best for me today." And I don't remember the charges or the outcome of that hearing. It was 16 years ago. But I always remember the raw fear of this young man and the immense responsibility that was impressed upon me as a law clerk for the public defenders. Public defenders are the constitutionally mandated first line of defense for everyone's rights. We push back against authority, whatever that looks like, a bloated government, state government, a false accusation, a harsh sentence. A well-trained and well-funded public defense system protects the integrity of the entire justice system. In 2023, Minnesota made a historic investment in our justice system by fully funding Minnesota public defenders. And right now, about 30% of the 550 line attorneys we have started with our agency after that investment. 30%. Half of those attorneys were hired at the bottom two steps, meaning we're training them. With just as an FYI, 55% of our line attorneys started after January 1st of 2020. And I'm not proud of this, but in the 10th district, we probably have soy sauce in our break room that's been around longer than that. 22% of our public defenders were hired at the top of the pay scale, meaning they left other positions to come to public defense. Often, they were former public defenders who came back when it was finally possible to do this work and say, you know, put your kid into hockey, right? We've had several three-quarter-time public defenders who had private firms and work that they were doing, who were lured into closing up their private practices to join public defenders as full-time employees once we got those wage increases. Mr. Kyer, who just spoke, just let you know that we run a very tight budget and we're scrappy. At my office, we were using an actual carpet sweeper like Alice and the Brady Bunch well into 2020, I believe. If we can't secure a cost of living adjustment this biennium, these employees will have gone a total of 3 years without raises. Many of these new hires who are starting families and paying off student loans, they won't stick around. We'll have invested a tremendous amount of time and money to train them for positions with prosecutor offices who've increased their wages to match and exceed ours, or private defense firms. Please do not let this progress disintegrate. Our ask today ensures that we retain our talent and build on that capital. So as a state, we can continue to do our best for our clients every day. Thank you.
Thank you, Ms. O'Rourke. It sounds like the substantial increases we passed in the last several years for public defender budgets have had their desired effect to draw people back.
It certainly has, Your Honor, and we just want to make sure that we can keep them there in the future going forward, because it was such a profound investment that we're all deeply appreciative for. Thank you.
I've actually had one PD I'm thinking of in particular thank me for her ability to put her kids into college as a result of that increase. So, members, the plan is to lay this bill over until we get a little more direction from the Finance Committee as to how we're going to handle budget bills or finance proposals this year. But while we have the testifiers here, any questions or discussion? I'm not seeing any. Thank you to all the public defenders for all the work you do protecting our constitutional rights in Minnesota.
Thank you.
This, Senate File 4154 is laid over. All right, Senator Seeberger. Members, this is the last bill on this afternoon's agenda. Senate File 4537. The anticipated action is to either send this to Housing or to the Senate floor. I seem to have lost Senator Port. Maybe Senator Seeberger, you know what Chair Port's preference is on that.
Thank you, Mr. Chair. Unfortunately, I do not. I'm hearing the preference is to send it to the Senate floor.
All right, we'll double check with Senator Port's office. I understand. Well, we'll find out for sure. Okay, why don't we get started here? Senate File 4171. Members, this has been distributed to you. There is an A2 amendment, and this is the first committee. So Senator Seeberger moves adoption of the A2 as an author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Seeberger, to your bill.
Thank you, Mr. Chair and members of the committee. I am here on Senate File 4537 as amended. This bill simply expands the ability to request an expedited hearing for eviction to instances where the tenant seriously endangers the safety not only seriously endangers the safety of another resident, but also if they assault the landlord or the landlord's employee or contractor. So what we're seeing is, while the law states that if a tenant seriously endangers the safety of other residents, that gives an avenue to an expedited eviction action. We're seeing staff and contractors who are there to perform work being assaulted, intimidated by a resident, and not being able to bring an expedited eviction action. So this just gets the matter in front of a judge quicker. The A2 amendment is an agreement with the parties. I can say I got peace in the valley too. So I'm pleased to be here on this bill. I have a couple of testifiers who can, were you testifying or just answering questions?
I was going to testify.
Okay, I have a couple of testifiers here too who can give you a little more insight into this bill.
All right, Mr. Bagnoli.
Mr. Chair, members of the committee, Joe Bagnoli with Winthrop and Weinstein Law Firm on behalf of the Twin Cities Housing Alliance, which is an alliance of housing developers and owners of buildings. We brought this bill to Senator Seeberger, excuse me. Senator Seeberger, for the reason she described. I don't want to overstate how prevalent this is, but at least a handful of our members have had serious assaults, knives being held to property managers' throats, and in an inability to access the courts quickly on that. It seemed to be almost an oversight at the time, but we initially had broader language that would have included not just the property managers, but any guests of the guests of tenants. In working with Mr. Elwood from Legal Aid, we've narrowed that down and narrowed the language to a place where we think it's appropriate. And so we are comfortable with the bill and we urge your support.
Mr. Elwood.
Mr. Chair, Mr. Chair, members, Ron Elwood with Legal Aid. I want to thank the Twin Cities Housing Alliance for coming to us with this proposal and asking for our input and for accepting our suggestions. And similarly, I want to thank Senator Seeberger for adopting our proposals. And we think this makes sense. The law currently, I mean, there really is a gap in the law. I mean, if a tenant attacks another tenant, there's a right to an expedited eviction, but not if they attack the landlord or a contractor or staff. And that just simply doesn't make any sense to us, or it's just not common sense. So I think this is an important bill to address a problem, but it also is, we think, perfectly tailored to address the issue. Thank you very much.
I love how much common sense there is in this room today. Ms. Taphorn, Washington County HRA.
Good afternoon, Chair Latz and committee members. My name is Melissa Taphorn. I'm the Executive Director of the Washington County CDA in the wonderful district of Senator Seeberger and among others. And I'm also the Legislative Co-Chair for the Minnesota chapter of NARO. We represent 150 housing and redevelopment authorities across the state of Minnesota. Speak today in favor of Senate File 4537 to extend the expedited eviction proceedings in cases of violent behavior and serious threats towards staff and our contractors. Housing and redevelopment authorities own and operate a variety of rental properties. Combined, we estimate that HRAs own over 35,000 rental homes in Minnesota. As property managers and owners, we have a responsibility to create a safe living environment for our residents, but we also have a responsibility to provide a safe working environment for our property management, maintenance staff, and contractors. Some of us employ those people directly. Some of us contract out for those services. They are trained in conflict resolution and de-escalation techniques. However, if they're attacked, they don't deserve to continue to work in that environment to go through the eviction proceeding process. Expediting that would be very helpful. I asked our members for examples of recent crimes, violent crimes against their staff. Received a long list, but shared just a few. Our property manager was assaulted on the property. She was never able to return to work. The maintenance guy was pulled from his vehicle in the parking lot and beat up by Tenants, concussion, and other injuries were sustained. Son of a resident threatened staff, then came back and shot up her car, which was parked outside the building of the front of the building. He was upset with the officer because she would not allow him into the building. On-site building security was chased by a resident with an 8-inch knife. The resident was punching the security desk and kicking the door, screaming he was going to kill the security staff. Housing for all Minnesotans is a strategic priority, and housing is not possible without the management and maintenance staff that keep our housing open and running. This bill restores that right to basic safety for everyone in our housing. So thank you, Senator Seeberger and committee members, for your time and consideration of this bill. Thank you.
Thank you, Ms. Taphorn. We'll go to discussion now. Senator Limmer.
Thank you, Mr. Chair. Question I have is kind of how the bill in the delete everything amendment is formatted. We have general statements about, in the existing law, recognizing behavior that seriously endangers the safety of other residents, found on lines 1.5 and 6. On 1.7, talking about intentionally and seriously damaging the property of the landlord. But the new language makes reference to a specific statute. And in the future, does that mean that we're going to have to write specific statutes for every possible crime that assaults the property or the landlord or other tenants? I'm just curious if that's still a reason to effectuate an expedited hearing.
Senator Limmer, the citation to the assaults is the standard definition of assaults, harm and assaults fear in Minnesota criminal law.
Okay.
So it's not specific to this particular kind of provision. It's the standard assault language.
So, Mr. Chair.
If that helps answer your question.
Mr. Chair, then and perhaps council can answer this, the existing language only made reference to assaults on residents of the property or damage to the property, and now we're specifying a landlord or the landlord's employee contractor. Is that what we're filling the gap in?
Yeah, the existing language does not reference assaults. It's just engages in behavior that seriously endangers the safety or seriously damages. So the assault is specific to another person in the new language there, as assault is defined in 609.02 subdivision 10.
Okay. Thank you.
Does that answer your questions?
Yes, it does. Thank you.
Senator Holmstrom.
Thank you, Mr. Chair. As I look at lines of the A2, I look at line 1.2, and we increased the penalties to $750. Was there, can you explain the process that went into choosing that number over the original 500?
Senator Seeberger.
Thank you, Mr. Chair. I'll turn it over to, yeah, go for it.
I think, Mr. Chair, Senator, the original proposal was 1,000 from, and we settled on 750. There was nothing more to it than simple negotiation. Perhaps I should have negotiated harder. But it was in the course of, there was a variety of changes that were involved in this, and this was something that was important to legal aid, and we ultimately were comfortable with it.
Senator Holmstrom, a follow-up. Senator Kroon.
Thank you, Mr. Chair. Looking at, just trying to understand the reasons for the changes in the A2. The existing law has the seriously endangers the safety of other residents, and you're, as introduced, kept that language and expanded it to other persons. And I see in the A2, you keep the seriously endangers language in there for the residents, but you change it to assaults for landlord or landlord's employees or contractor. You add the cross-reference for the definition of assault. I'm tracking so far, but what I don't understand is why you're limiting it to landlord or landlord's employees. And if we're going to do this, why not include assaults on guests or UPS drivers, Amazon delivery drivers? Why did your author's amendment just limit it to landlord or landlord's employees?
I'll let
Mr.
Mr.
Elwood.
Elwood tackle that one.
Mr. Chair and Senator Kroon, that was at the request of legal aid and our attorneys. And there are others in the housing advocacy world, including other legislators, who were concerned about the breadth of that word. And part of the issue, for example, is we're concerned about if somebody a tenant is in a relationship with an abuser, they don't live there, but the abuser comes and does, others. And so we just don't, we just wanted to make sure that it was, the issue we understand it, as we understood it from the proponents, is the safety of the staff, the people that work there, and the landlords. So we just wanted to make it tight.
Senator Kroon.
Thank you, Mr. Chair. I guess I can kind of see on line 1.8 of the as-introduced version, it says, quote-unquote, persons on the premises. Kind of see how that can be a little bit broad, but it seems like the A2 tightens it up too much, and you could at least include guests and invitees. And maybe there's other words you could use to expand it to make sure that it would include delivery drivers, for example. But it seems like the expedited eviction procedure, to me, if somebody assaults somebody, a guest or an invitee, that should be available as well. I'm just getting your thoughts on that.
Mr. Chair, I'm not sure there was a question, but
I'm not sure.
I could
Senator
respond.
Kroon, you seeking their feedback?
Mr. Chair, thank you. I'm just seeking their feedback before I would make an author's or oral amendment.
Mr. Bagnoli.
Mr. Chair, Senator Kroon, committee, I think I understand your concern, and clearly when we introduced the bill, that was one of our concerns too. I would say in the hierarchy of concerns, the safety, and we have great difficulty with employees for obvious reasons. If you get assaulted, it sends sort of a chill through all of the other employees, and these are not, these are well-paid employees, but they're not, there's other opportunities to find work without getting assaulted at work. So that was our principle. We would have preferred to have it a little bit broader. I think, and I would say, I can describe a situation where somebody comes and gets assaulted in the same way. That's dramatic and scary. I think the concern that legal aid, I'm going to talk for my friend Ron here a little bit, was I show up with my friend. I'm a tenant. Ron's a tenant. My friend's drunk. He gets in a fight with Ron. We use that to kick Ron out. And in that case, who was the assaulter? Who was it's a little bit, that's on the one end of the spectrum where you say, well, we shouldn't probably have that person kicked out because it was just a fight between two guys. That then starts to get more nuanced if you have people of different races, different ethnicities, when there was just a fight. But sometimes things aren't, and I think some of those are legal aid's concerns. I understand that, and I understand it as I think he understands my concern of, but what happens if somebody shows up and grabs the 17-year-old daughter of somebody? That's bad, and we shouldn't do that, and they would agree. How to write that into law is very, very difficult, and given the time crunches we were in, we weren't able to figure out a way to not allow for one and maybe allow for the other. And so we got to where we got, and maybe perhaps in the future we can figure out something else. But I think this, for our purposes, we have real concern about the cleaning crew that comes in that come in regularly, that's there all the time, the property manager and et cetera. So this is where we got today, and perhaps we can figure out something more in the future.
Mr. Elwood.
Mr. Chair and Senator Kroon, one of the things that I know we were concerned about, and probably the primary thing, which is why we wanted it to be as narrow as possible, if you're in a situation with an abuser and they come, and then there's an altercation between the resident and the abuser, one could potentially see how a landlord might want to say, well, the resident assaulted the abuser and therefore could use this as an excuse to evict somebody because their person's calm, he's loud, et cetera, the whole thing. And I know, we've been working on that other bill with respect to domestic violence, and I know you're sensitive to that. But I think that was probably the primary reason we wanted to keep it to staff and landlords and property managers. I know, as Mr. Bagnoli pointed out, I think we could think about ways to expand it, to address that, and maybe avoid the problem we're concerned about. We just weren't able to do that in the time we have for a deadline.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. And I'll resist the urge to offer an oral amendment then, respecting the time constraints you had and how you ended up where you eventually did. I think I would say there probably is language that could guard against the domestic violence situation while still allowing guests, invitees. And I'm struggling on the third category because I know it's there. That would get at what we're talking about. So rather than do it on the fly, I'll just, maybe we can do it at a future date sometime. And we'll just leave it at that. So thank you.
Any further discussion? Senator Holmstrom.
Thank you, Mr. Chair. I want to clarify back to lines of the A2, 118 through 120. So is this penalty assessed or required anytime a landlord fails to prove that an assault happened? If they fall just barely short of proving that the assault is real, are they going to be required to be fined?
Mr. Elwood.
Mr. Chair and Senator Holmstrom, that section of law was in there with the original fine, not fine, but penalty for the failure to essentially to make a false charge. I mean, that's what that is. It's kind of a balancing act here. If you're going to have an expedited eviction and get somebody out quicker, but you've made a false accusation at that, then that's the quid pro quo for being wrong. Given the fact that I think our logic here was if we're going to expand the number of expedited evictions, we ought to make sure that, we've got the proper deterrent for making sure that that's a valid claim in the first place.
Senator Holmstrom.
Just as follow up, and again, we're extending it, so I think it's fair to really try to dig in and understand this. So if two of my tenants get into a fight and an assault occurs, but it's just off a camera, and we go there and we don't have every piece of information we need for the judge to rule in our favor. The judge simply ruling against us would mandate a fine. Is that correct?
Mr. Elwood.
Mr. Chair and Senator Holmstrom, the language I think is straightforward, as you say. If the court determines that they did so without sufficient basis, there would be the penalty. So,
Mr. Bagnoli.
Sorry, Mr. Chair, Senator, but the decision that there's not sufficient basis is different than there's not sufficient proof. It's sort of, you can't just wildly make an accusation that this person did it. That's what they're trying to get at. We would say typically I was going to let your counsel there. Typically, we are comfortable with it going up because typically we do not, we plead these with sufficient basis. They are They are the pretty extreme, what we would describe as pretty extreme. If the judge says, yeah, but this is not expeditable, you have sufficient basis, but there's not sufficient basis to actually do this on an expedite, or not sufficient basis. There's not a reason to do this on expedited, which is different. It's got to be pled with specificity, and that's what, it's not just an idle threat.
Senator Holmstrom.
Thank you, Mr. Chair. Yeah, I wanted to clarify that the judge still would have discretion, and it seems like that is the case, so.
Right. Sorry.
It's also up to the max, so
Right.
it's not a mandatory 750. It's
Yeah.
anything up to that amount.
Yeah.
Any further discussion on Senate File 4537 as amended? The intention is to send this to the floor. Not seeing any. Senator Seeberger moves that Senate File 4171 as amended be recommended to pass. Senate File 4537 be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Members, we're going to be in recess until 6 o'clock. There's a possibility that the time might get delayed a little bit, so just watch your emails. I guess staff will send out a message if it's going to be a little bit later than that. And we will go until the agenda for this evening is completed. So we're going to grab dinner, do it before the committee reconvenes. We are in recess.